claimant seeks a preliminary issue on an issue of construction. It's at a very early stage in the arbitration, nothing's really got going, but the claimant says, because this point is decisive, if it's decided against me, that's the end of all my claims in the arbitration. And the claimant says that. The other side protests against the preliminary issue, but the end gives in, and it's a preliminary issue by consent. The tribunal makes a consent order. The party seeking the preliminary issue, the claimant, loses and is out of time for a Section 69 appeal. The claimant then turns around in the same arbitration and amends its claim, keeping almost all of the existing allegations, and put it on a new basis. Can the respondent turn around and say, well, that's an abusive process because you have represented to me that the issue which would be decided will be decisive of every issue and all the claims in the case? Is this an issue estoppel situation? You test it this way: if the claim was brought in one arbitration and it failed, could a claim be dressed up in another way and brought in a separate arbitration? Answer: no, because of issue estoppel and the principles in Henderson and Henderson. The interesting feature of the Daewoo Shipbuilding and Marine Engineering and Songa Offshore Equinox case, that sort of abusive process issue estoppel argument, while perfectly good if there were two arbitrations, could not work as a matter of law within one arbitration, because effectively you always had a right to amend, and therefore you could have as many second bites, even if you decided you didn't like the preliminary issue and you decided that the preliminary issue shouldn't be decisive after all. The issue came before a very distinguished tribunal, and they found that issue estoppel and Henderson abuse of a process estoppel would apply equally in one set of proceedings as to two. Found a case, a decision of Mr. Justice Jackson's in Ruttall, Plantyre and Secretary of State for the Environment, which said that in single sets of proceedings, Henderson had no place. It was simply a question of applying for permission to amend on ordinary bases. If it was an early stage of the proceedings, you could get permission to amend and the position would be dealt with in costs only. That case hadn't been found before the arbitrators, but it came up on the Section 69 application for permission to appeal, which was argued unusually, fully orally, in the TCC before Mrs. Justice Jefford. The decision of Mrs. Justice Jefford is interesting and useful because she considers all of the authority on the point. And that consideration shows that the Ruttall case is a complete outlier, which she declined to follow, it not being reasoned and, in her view, wrong. She preferred to follow other cases, BT Pension Scheme Trustees and BT, Gruber and AIG, Sailor Austria and Tokyo Marine. Those cases say that it is unusual for issue estoppel and Henderson abuse of process to apply in the same proceedings. But there is no principle why it should not apply on the facts. And therefore, a DSME's argument, which was that the arbitrators were wrong as a matter of law ever to apply Henderson in the same proceedings, must fail. And of course, the judge did not need to get into whether the arbitrators, having applied it, were right in that decision. Takeaway points? Well, when you're applying for a preliminary issue and you really want to persuade the other side and the tribunal to give it to you, and be careful about making sweeping promises that it's the end of the whole shooting match and the end of everything, because those promises will probably make it unfair and abusive for you to turn around later and say, well, when I said it was final, I changed my mind. If you're on the receiving end of an application for a preliminary issue, then you should try to tie down the other party as to what precisely the consequences will be of an adverse decision, i.e. a decision in your favour. And lastly, just a parting word on the case. It's interesting that even in consent order cases, where it's quite difficult to show a contractual agreement, the very extreme nature of the representations made by DSME, that it will absolutely be the end. Please accept what we're saying, because it will absolutely be the end, and it was then accepted. Also, in the arbitrator's view, and the court said that the arbitrators had not committed any error of law in that, was so strong as to amount to a binding contractual agreement. Therefore, they were no longer able to run the point, simply because that would be in breach of contract, where they contracted they never would. An interesting case and food for thought when you're applying for preliminary issues. Thanks very much.